We'll start with charges. Chapter 6 of Companies Act 2013, section number 77 to 87. It is governed by companies' registration of charges rules. A charge is a right created by any person, including a company, referred to as the borrower and on its assets and properties in favor of financial institutions, or referred to as a lender. Now, section 216 defines charges as to mean an interest or lien created on the property assets of the company or any of its undertaking, or both as security and includes a mortgage. The following are the essentials of the charges. There should be two parties for the transaction: the creator of the charge and the charge holder. The subject matter of the charge, which may be current or future, and the intentions of the borrower to offer or more. Now, duty to register charge is on every company within 30 days of its creation, whether the charge is created within or outside India, or any of its property, whether tangible or intangible. Now, creation of registration of charges, Rule 6. ROC issues certificate of registration in COT2 and CHG3 in favor of the charge for modification. Now, there is a provision that if they are failing within 30 days, then additional 30 days, 60 days are given with an additional fees. If the charge is created on and after the ordinance 2019. We have next is there's a provision that subsequent registration of charge shall not prejudice any right acquired in respect of any property before the charge is actually registered. Now, not applied to charges in consultation with the RBI. Thus, all types of charges created within or outside India on property or assets on any of the property undertaking, whether tangible or intangible, situated inside or outside India, shall be registered. Now we have section 77(1) that shall be issue a certificate of registration by ROC in CAG 2, and this created no charges created shall be taken into account by the liquidator or any other creditor unless it is duly registered and a certificate of registration is given by the registrar. What is the time limit for registration? CAG 1 is for charges other than debentures, and CAG 9 in case of CAG 9 in case of debentures. Then the continuation of delay, it can be done if the company is not able to register the charge within 30 days, then there's a laws change, and that's it. Condemnation of delay of the company, read by section 87 and rule of 12. It shows that if a company fails to register the charges even within 300 days, then in such case it shall seek further extension in accordance with section 87 from the central government. Now, what is the application for registration of charge? If a company fails to register the charge within a period of 30 days specified in section 77, the charge holder may apply to the registrar for registration of the charge within the time prescribed. We have on receipt from an application, ROC shall forward a notice in this regard to the company, and within a period of 14 days after the notice, the registrar shall register the charge as per the instructions given by the charge holder. And an opportunity of being heard is given to the company also. Now, section 77 to apply in certain matters acquiring property and charge and modification. Company relating to registered charge so far as may apply to a company acquiring any property subject to charge and any modification. Any modification in terms of or conditions to the external operations of any charge registered under that section. Provision related to condonation of delay shall apply mutandis to the registration of charge on such property. A notice of charge by any charge on any property or assets of a company or any of its undertaking is registered under section 77. Any person acquiring such property is having deemed knowledge of such charge. Now, register of charges have to maintain at ROC office also, and that is the MCA portal. And satisfaction of charge, rule 8 says that company needs to intimate within 30 days from the date of such payment or satisfaction in form CHG 4 along with the fees, and the registrar may also condone delay within a period of 300 days on such prescribed fees. Now, in case the satisfaction of charge may delayed beyond 300 days, can only be condoned by central government, and CHG 8 should be filed for the same. However, in case of specified IFC public company, satisfaction of charge will be registered within 300 days on an application by the company and payment of additional fees. Now, listen to such intimation. The registrar shall issue a notice to the holder of the charge calling a show cause within such time not exceeding 14 days as to why payment or satisfaction in full should not be recorded as intimated to the registrar, and in no case is shown, then the registrar shall order that a memorandum of satisfaction shall be entered in the register of charges maintained by the registrar under section 81 and shall inform the company. It should be noted that no such notice is required to be sent by the registrar to the holder of charge if the intimation to the registrars is in specified form and signed by the holder of the charge. If the cause is shown to the registrar, you shall record a note to that effect in register of charges and inform the companies accordingly. In a certificate of registration of charge, where the registrar enters a memorandum of satisfaction of full in charge, then the ROC issues a certificate and Form CSG 5. The power of registrar to make entries of satisfaction in absence of the company, even if the company fails to send intimation regarding satisfaction of charge, the registrar shall issue still issue memorandum of satisfaction in respect of the evidence to the satisfaction that the debt for which the charge was given has been paid, or the property undertaking charge has been released from the charge or has ceased to be the part of the company's property or undertaking. The registrar shall inform affected parties within 30 days of making entry in the register of charges. Now, intimation for appointment of receiver or manager, it's given under section 84. If any person obtains an order for the appointment of a receiver or of a person to manage the property subject to a charge for company, he shall within 30 days from the date of passing of the order or from the date of appointment of the notice, the registrar along with a copy of the order. Intimation must also be made if the person appointed as receiver or manager ceases to hold office within in Form CHG 6 along with the fees. Now, register of charges maintained at the company. Now, Rule 10 and 11 of companies registration of charges Rule 2014. Every company shall keep at its registered office a register of charges in format of CHG 7, which shall include therein all charges, floating charges affecting any property or asset of the company and any of its undertaking, in each case the detailed particulars. All the entries in the register of charges shall be authenticated by a director or a secretary of the company or any other person authorized by the board for the purpose. The register of charges shall be preserved permanently and the instrument creating charge or obligation thereon shall be preserved for a period of 8 years. Inspection, register of charges and the instrument of charges shall be kept open for inspection during business hours by members, creditors or any other person subject to the reasonable restrictions. Punishment, contravention, and not reading. Section 87 is for rectification by the central government with register of charges, condemnation, delay, fine. The central government is satisfied on application by the company or any person interested that any omission to give intimation to ROC for the satisfaction of charge or modification in respect to any satisfaction was accidental or due to inadvertence or other sufficient cause, or it is not of a nature to prejudice the position of creditors or shareholders of the company. In such a case, the government may direct that the time for filing of the particulars or payment or satisfying or intimation shall be extended, or that the omission or misstatement shall be rectified. This section implies that the central government has power to condone delay even beyond the time limit specifically mentioned or to rectify the omission or misstatement. The application may be filed by the company or any other person interested in Form CHG 8 along with the fees. Now we have is verification of instrument according to rule 3.4 companies registration of charges. If the instrument or deed relates solely to the property situated outside India, then in such case copy have to be verified by a certificate issued either under the seal of a company or under the hand of the director, company secretary or authorized officer or the charge holder. If the instrument or deed relates whether wholly or partly to the property situated in India, it has to be certified issued under the hand of director or CS or authorized officer. Now, what are the consequences of non-registration of charges? So, all types of charges created are to be registered. If the charge is not registered, the ROC then it becomes void as against the liquidator and any other creditor of the company. However, it does not mean that the debt is not recoverable. So long as the company does not go into liquidation, the charge is good and may be enforced. Void against liquidator, the charge is not registered. The liquidator On winding up of the company can ignore the charge and can treat the concerned creditor as unsecured creditor. The property will be treated as free of charge, that is, the creditor cannot sell the property to recover its due. Void against any creditor of the company means that if any subsequent charge on the property is created when the earlier charge is not registered, the earlier charge have no consequence and the later charge of register would enjoy priority. Thus, non-filing of particular charge does not invalidate the charge against the company as a going concern. It is void only against the liquidator and the creditors. At the time of liquidation, the company itself cannot have a cause of action arising out of non-liquid non-registration. It was given in the case of Independent Automatic Sales Limited versus Novels and Fosters. Now, ONGC Limited was the official liquidator from Bika Mills. ONG has not been able to point out whether the so-called charge on the basis of which it was claiming preference as secured creditors was registered or not. In the light of this failure, ONGC could not be treated as secured creditor in view of the specific provision of the Act. This, however, does not mean that the charge is void and debt is not recoverable so long as the company does not go into liquidation. The charge is good and may be enforced. What are the particulars of the charge to be entered? Date and description of the instrument, total amount secured, date of resolution, authorizing general description of the property, copy of the deed instrument, list of terms and conditions of the loans, and the names and address of the charge holder.